This morning, highlighted in our media this morning, and highlighted in the document. I'll be elaborating on the terms substantive hearing or promotion, but I should just point out to you very quickly, violatively have been breached.
Yes.
My Lord, it's not in the interest of Mr. Wanjigi to proceed to Nyeri. One has either to walk to Nyeri town or to go by road. I believe it was Nyeri to Nairobi, and he was involved in a car accident.
Number 251 of 2018, and a stay of those criminal proceedings. And my Lord, it is important to put this matter in context. My Lord, if you look after they pleaded the affidavit in support of this application, there is an order made by your brother, Mr. Justice Mwita, which is found on page 1. And that order granted anticipatory bail to Mr. Wanjigi, and it further gave an order prohibiting the police from trespassing or breaking into Mr. Wanjigi's compound. My Lord, after page 1, on the second page, there's an amended petition, which was the basis upon which this order was granted by your brother, Mr. Justice Mwita. And that amended petition is relevant in the sense that, my Lord, the averments that are contained in the petition, particularly on paragraph 23, talks about recovery and retrieval of arms from Mr. Wanjigi's house, and they are enumerated in paragraph 23. That they are licensed. They're not arms which are being held illegally. My Lord, there's been no answer to this petition, although the proceedings are ongoing. And the criminal case number 251 in Nyeri, my Lord, as officers of the court, we wish to inform the court that actually there's a charge against Mr. Wanjigi for importation of illegal arms. The very same arms which are subject matter of a petition which is before the Constitutional Division of this court. And no answer has been given or response to that petition by the Inspector General or the Director of Public Prosecutions, who has got the conduct of the prosecution in Nyeri. My Lord, you'll notice from that order that the anticipatory bail was in force from the 17th of October and is still in force. Further order that was made by your brother, Mr. Justice Kimaru, and that is found on page 34, where another anticipatory bail was granted to Mr. Wanjigi. The importance of that anticipatory bail that was granted by your brother, Mr. Justice Kimaru, in respect of these proceedings, is that the police actually responded to it on the official tweet of the National Police Service, which is found on page 35. And the police have said those individuals should therefore not bother turning up at the CAD headquarters. They are not persons of interest to the police as of now. And further, this was on the 6th February 2018. The National Police Service wishes to state that neither Hassan Joho, Jimmy Wanjigi, Devin D, nor the 9 others who have sought anticipatory bail are being sought as of now in connection with the commission of any crimes. This is just how many days ago? Less than 20 days ago. About 20. Status of the firearms subject matter of the charge in Meru is a pattern of harassment and intimidation. Also in the pleadings, it would be noticed that Mr. Wanjigi was one of the persons whose passports were recalled, and thankfully, because of the order of the court, despite being the immigration officials trying to turn him away at the airport and him spending a night at the airport, eventually was allowed to travel to Zimbabwe. All this in a space of about 5 months. Harassment, intimidation, and abuse of the legal process. My Lord, there are 2 sections, 2 articles in the Constitution which is very important because they're not even qualified. They are in themselves only subject to the provisions of the Constitution. Article 28, every person has inherent dignity and to have the right to have that dignity respected and protected. Whether you are a prisoner, you are an accused person, that dignity must be respected. And in the manner in which Mr. Wanjigi was stopped right in the middle of a highway, with officers who, my Lord, will seek to show in these proceedings later that the officers who were involved in stopping Mr. Wanjigi on the highway had just eliminated 6 people an hour before near Mr. Wanjigi's office on the allegation that there were thugs. Take the torture in any manner, whether physical or psychic. This is in the Constitution. F, treated or punished in a cruel, inhumane, and degrading manner. These are all in the Constitution. And some of them are in accordance with.
I cancel the statement of facts as well as the verifying affidavit and the documents exhibited thereto. The matter before me at this stage is an application for leave and directions that if that leave is granted, it operates as a stay of the decision or proceedings in question. At this stage, the purpose of leave concerned with is whether the applicant has established a prima facie case that warrants a hearing at the inter partes hearing of the substantive motion. The applicant's case, as disclosed in the pleadings filed before me, is that the decision to charge him is constitutionally and procedurally flawed in that his constitutional rights have either been violated or are threatened with violation. There is also an issue as to whether the court that issued the orders for his arraignment had the powers to do so. It is also contended that in deciding to charge him, the respondents have taken into account irrelevant matters. It is further contended that the decision to charge the applicant is in breach of the orders of this court. These are issues in my mind which constitute serious constitutional and legal issues as appreciated in Korea and 3 others versus the Attorney General. So long as the judicial review judicial review remained the only legally practicable remedies for control of administrative decisions, and in view of the changing concepts of good governance, which demand transparency by any body of persons having legal authority to determine questions affecting the rights of subjects under the obligation to act judicially, the limits of judicial review shall continue extending, and the intrusion of judicial review remedies in criminal proceedings would have the effect of requiring a much broader approach than envisaged in civil law. Similarly, in Rebivac, it was held that judicial review has become the most powerful enforcer of constitutionalism, one of the greatest promoters of the rule of law, and perhaps one of the most powerful tools against abuse of power and arbitrariness. In my view, the issue raised herein not only go to the root of the maintenance of the rule of law, but abuse of power as well. It is therefore my finding that the applicant has established a prima facie case for purposes of leave, which I hereby grant in terms of prayer 2 and 3 of the Chamber summons dated 1st of March 2018, and I direct that the motion be filed and served within 7 days. As regards the stay, the applicants intend to challenge not only the process by which the subject criminal proceedings were commenced, but the place of trial as well. In the circumstances, it would be an exercise in futility to allow the intended criminal proceedings to proceed, as to do so is likely to render these proceedings superfluous were they to succeed. In the premises, I direct that the grant of leave shall operate as a stay of criminal proceedings in Chief Magistrate Court in Nyeri, in criminal case number 251 of 2018, or any other proceeding arising from the subject matter of the said Nyeri criminal case number 251 of 2018 before any court subordinate to this court, pending the hearing of the motion or further orders of this court. Dr. Amino has, however, urged this court to direct that the applicant should not be charged with any criminal case without recourse to this court. In my view, such an order would be too broad. What this court is entitled to do is to stay the proceedings in question, and to my mind, the proceedings in question are the Nyeri criminal case number 251 of 2018, and to avoid abuse of court process, the subject matter of the said proceedings, which is what I have dealt with herein above. The cost of these proceedings will be in the course, and we can take a date for directions.
Just before we take the date,